Alternative Party, Red United, called on the Attorney General's chambers to provide a detailed and public explanation of the rationale behind their amendments to the charges and their sentencing recommendations against former Transport Minister Iswaran. In a statement issued on Thursday, RDU's Secretary General, Ravi Philemon, stressed that this is a matter of significant public interest, compelling the party to raise critical questions about transparency. He emphasized the need for such clarity to restore public confidence in Singapore's institutions. The statement referenced the sentencing of Mr. Iswaran to 12 months imprisonment for accepting valuable gifts under Section 165 of the Penal Code. We respect the right of Mr. Iswaran and his family for privacy as they come to terms with his crime, but it is important to discuss the offences committed and how the case has unfolded over the past 15 months, said Philemon. RDU's call comes on the heels of an earlier statement by the Progress Singapore Party, which also sought greater clarity from the AGC regarding its prosecutorial decisions in the Iswaran case. The AGC's decision to amend the initial charges against Mr. Iswaran has raised significant concerns. Initially, the former minister faced 35 charges, including 2 under the Prevention of Corruption Act, for corruption involving over 400,000 Singapore dollars worth of valuable items. However, days before the trial was set to commence in September 2024, the AGC reduced these to lesser offences under Section 165, drastically lowering the potential penalties. RDU has questioned why the AGC initially determined that the PCA charges were justified, and why this assessment changed as the trial approached. Philemon asked, was there new information that made the original charges untenable, or did the AGC reassess the risks involved in proceeding with a full trial? The public deserves clarity, especially given the serious nature of the accusations. Another point of contention highlighted by RDU is the AGC's sentencing recommendation. Despite the extensive nature of Mr. Iswaran's wrongdoing, the AGC recommended a sentence of just 6 to 7 months. However, Justice Vincent Hung handed down a 12-month jail term, almost double what was sought by the prosecution. Philemon remarked, as a former minister, Mr. Iswaran occupied a position of immense responsibility, and his actions not only betrayed public trust, but also set a dangerous precedent for how corruption cases involving high-ranking officials are managed. Given this, we urge the AGC to address if it took such a lenient position, and whether such considerations are consistent across similar cases, he added. RDU also expressed concerns over the status of other individuals named in connection with the case, such as Mr. Ong Beng Seng and Mr. Lam Kok Seng. While Mr. Ong has since been charged, RDU questioned why it took so long and what criteria the AGC used when deciding whether to pursue charges against associated parties. This piecemeal approach to prosecuting such a high-profile case suggests a lack of consistent standards and undermines public confidence in the impartiality of our legal system, said Philemon. Despite concerns over the AGC's actions, RDU praised Justice Vincent Hung for imposing a sentence that more appropriately reflected the seriousness of the offences. His decision underscores the importance of accountability and reinforces the need for robust sentencing to reflect the gravity of offences committed by individuals holding high public office, Philemon added. RDU stressed that transparency is crucial to upholding good governance, asserting that Singaporeans deserve clear answers on matters that may compromise the integrity of the public service. The party expressed hope that the authorities would address these concerns and build long-term trust and understanding through enhanced openness. In a statement issued on 24 September, the AGC cited substantial evidentiary risks in proving the original corruption charges, which involved Ong Beng Seng and Lam Kok Seng. The AGC noted that proving the original corruption charges under PCA would have been difficult due to the involvement of both Iswaran and Ong as primary parties. Both would have had to implicate themselves to establish corrupt intent. The AGC explained that there are 2 primary parties to the transactions, and both would have an interest in denying corruption in the transactions. This made securing a conviction for corruption highly uncertain. In light of these risks, the AGC amended the charges to offences under Section 165 of the Penal Code, which carries a lower evidentiary threshold and a reduced maximum sentence of 2 years imprisonment. According to AGC, the amendment was made to ensure a fair and just outcome while considering public interest.